This panel is the surveillance state and domestic spying in the Obama era, tactics to end the Bush legacy. And what we want to talk about here today from a number of different perspectives is the ongoing domestic spying and infiltration and disruption operations in the United States against different communities and political organizations, and the efforts that people are undertaking to both identify and fight back against those, with the recognition that while much of this started in the Bush era, the Obama administration, far from reversing course, appears to be carrying forward many of the same policies and practices. And I think it's important within the National Lawyers Guild and advocates for justice that we have a realistic assessment of exactly what the state is in the United States as to these activities, and tactically what we need to be doing both legally and politically to end these kinds of operations and these efforts. Our speakers today are Stephen Goldberg, Imam Mahdi Bray, Eileen Clancy, and I am Mara Verheyden Hilliard. I'm a co-founder of the Partnership for Civil Justice with Carl Messinio, who may also be here a bit later. And I am co-chair of the National Lawyers Guild Mass Defense Committee, along with Carol Sobel, who I think is also here. Our first speaker is Stephen Goldberg. He is a civil rights lawyer based in Portland, Oregon. He has been practicing law for 34 years. And currently, he's a member of the legal team on the Al-Haramain v. Obama case, which is challenging the Bush administration's and now the Obama administration's national surveillance program. He is a former co-chair of the National Lawyers Guild International Committee, a member of the board of the Portland chapter of the Guild, and the Northwest Workers' Justice Project.
Morning. Pete Seda lived in Ashland, Oregon. He made his living as an arborist, pruning trees for the city and for wealthy Ashlanders. He was a devout, practicing Muslim and had started a foundation to generally promote Islam where he lived and to give away copies of the Quran to US and Canadian prisoners. He was supported by many in the Ashland community, including the rabbi, the one rabbi of the one synagogue in Ashland. In 1997, he met a representative of a Saudi Arabian charity called Al-Haramain Islamic Foundation, which agreed to fund Pete's work. Al-Haramain had branches in many other countries, and the US government believed it was financing terrorist organizations in countries such as Somalia and Chechnya. In 2000, funds from a Canadian donor were channeled through the Oregon Corporation towards relief work in Chechnya, and this ultimately led to surveillance of Seda and the Oregon Corporation, and an indictment ultimately of Seda based on improperly filing tax returns, nothing related to terrorism, followed. And that case is actually set for trial at this point in March coming up, although it's not clear that will happen. And if you wanted to Google Pete Sega or Al-Haramain Islamic Foundation, you could see a lot of articles and background about that case. So Al-Haramain challenged its designation as a terrorist organization. That's an administrative determination that's made by the Department of Treasury. And it's basically what the Bush administration did by cutting off financing to a lot of these foundations. Now, as part of the process, of the administrative process, the attorneys representing the foundation asked for discovery. And the government, this was in 2004, and the government basically provided various documents to the charity, most of which were newspaper articles, and one of which clearly seemed to be a summary of wiretap conversations, which were basically very innocuous, between a representative of Al-Haramain in Saudi Arabia internationally and several lawyers who represented Al-Haramain, who were primarily in the DC area. The document was marked top secret, but everyone assumed that it wasn't classified anymore. Why else would the government have disclosed this information to the lawyers as part of this process? 3 months later, that assumption changed when the FBI contacted the lawyers and other people who had received the document and said, we need to get this document back from you. It was inadvertently disclosed to you. And all copies of the document at that point were supposedly returned, and they were in fact returned from everyone who the FBI talked to, and they only talked to people in the United States at that point. In fact, the document was disclosed to a Washington Post reporter who returned the document to the FBI. And no one thought any more about this. This was in early August, in 2004, until December 2005. What happened in December 2005? There was suddenly an article in the New York Times which disclosed what we call the NSA warrantless surveillance or warrantless wiretap program, but which the government refers to as the TSP. You know what that means? Terrorist Surveillance Program. Now, in fact, as it turns out, the FBI had not gotten all copies of that document back. And one copy came to Tom Nelson, who is a Guild member and an attorney in Portland, Oregon. And Tom and I had worked together on issues regarding Palestine, and he gave the document to me, and we looked at the document together, and we decided, indeed, there was a violation of the Foreign Intelligence Surveillance Act, as well as various constitutional provisions, and we decided to file a complaint based upon FISA. And when we filed the complaint, initially, we filed the document with the court as a sealed document, so we followed the procedures fairly carefully. The legal team handling this case has expanded as the case has expanded and continues to go on. And Zaha Hassan and Lisa Jaskell, who are members of the team, are here. Ashley Albies, who's the president of the Portland chapter, is also on the team, as well as John Eisenberg, who's really become one of the lead attorneys and who's an attorney in Oakland and not yet a member of the Guild, but we work on him every day. Now, other lawsuits have been filed challenging the NSA program. CCR filed a suit, the ACLU filed a suit. There were all of these lawsuits filed against the various telecommunication companies that had cooperated with the government under this suit. But now, 3.5 years later, in October 2009, believe it or not, the only case left standing is the case that we're involved in, Al-Haramain Islamic Foundation versus now Obama. Now, the litigation history of this case is actually in the materials. You've gotten these CDs. And there have been, so far, 3 reported district court decisions and 1 decision by the Ninth Circuit Court of Appeals dealing with the state secrets issue. We're back now in the district court. And all of those citations are on that disc. There was an article in the New Yorker magazine in April, I think it was April 28th of 2008, which described our adventures in drafting our brief in front of the Ninth Circuit Court of Appeals, which is an amusing article, and you might want to take a look at that. It has been the most amazing and complicated case I've ever been involved in my years of practice. And there are 3 lessons I want to talk about today. Number 1, one can understand how the ACLU and the Center for Constitutional Rights gets involved in a case like this. But how do a team of lawyers from Oregon initially get involved in such a big case, which I'm sure the government is asked all the time, and why is it that this case is still going on through the courts? And I think, and I'm saying this mostly to the young attorneys here, but not exclusively to the young attorneys here, that the way I got involved in this case arose out of the political work that I was doing with Tom. Tom and I had worked on Palestinian work. Tom got involved with this case. He got me involved in this case. Nobody came to Stephen Goldberg or Lisa Jaskell and said, please represent us in this case. They came to us as members of the Guild and as a result of the political work we've done. I was involved in a case a couple of years ago, which I thought then was the most amazing case I'd been involved in, which was a challenge to the Army stop-loss program. And Lisa also worked with me on that case. And again, the National Guardsmen who challenged that program didn't search out Stephen Goldberg to handle that case. He wanted a lawyer. He came to the Guild because of the anti-military work that the Guild had done over the years. So the lesson is, if you want to get involved in these kinds of amazing cases, do political work. That's how you're going to get these cases. If you're not Jerry Spence, most of us are going to get these cases, not because of who we are, but really because of the work we do. And that's lesson number one.